All right, welcome to the deep dive. We are your guides, and we are about to plunge headfirst into a stack of source material generously made available by the University of London for educational purposes.
A massive thank you to them. It's great to be able to dig into these really important topics using their resources.
Absolutely. And just so you know, this particular deep dive is brought to you by Sinorbit Academy Sri Lanka, and it's intended purely for educational use.
That's right. So if you're listening and maybe preparing for exams on this subject, we really hope this helps. Good luck. We want to help you make sense of things and feel, truly ready.
Indeed. Our mission today is to take these materials, which are, well, incredibly detailed and insightful,
They really are.
and extract the absolute core, the nuggets of knowledge, the critical distinctions, the key cases to make a complex area of law understandable and, frankly, memorable.
It's a serious topic, no doubt about it. But our goal is clarity. We want to illuminate it for you, help you see how all the pieces fit together.
And the topic today is incredibly important: protection against domestic abuse under English law. It's a deeply complex issue, tragically prevalent, and one that demands a robust legal response.
Mhm.
The sources start us off with a crucial foundation: the official definition of domestic abuse, the one used across government and the public sector in England and Wales since 2013.
Yes, and that definition is fundamental. You really need to grasp it to understand the scope of the law here. It defines domestic abuse as any incident or pattern of incidents of controlling, coercive, or threatening behavior, violence, or abuse between those aged 16 or over who are or have been intimate partners or family members, regardless of gender or sexuality.
Wow, okay. That sounds deliberately broad.
It is. It's meant to capture the multifaceted nature of abuse, covering a wide range of relationships and ages.
And it specifically lists the types of abuse it encompasses, doesn't it?
Exactly. It spells out psychological, physical, sexual, financial, and emotional abuse. But it doesn't stop there. The definition also provides quite detailed explanations of controlling and coercive behavior, which are key concepts.
Right. Controlling and coercive. How does it define those? They sound similar, but I guess distinct.
They are distinct but related. Controlling behavior is defined as acts designed to make someone subordinate or dependent. Things like isolating them from support, exploiting their resources, depriving them of the means needed for independence or escape, and regulating their everyday behavior. It's really about stripping away someone's autonomy, their freedom.
Okay, so control is about subordination and dependence. What about coercive behavior?
Coercive behavior involves acts or a pattern of acts, like assault, threats, humiliation, intimidation, or other abuse that's used to harm, punish, or frighten the victim. So it captures both the manipulative side, the controlling side, and the more overtly aggressive forms of abuse.
That's really helpful to have those broken down.
And the sources also explicitly state this definition includes practices like forced marriage and so-called honor-based violence. Abhorrent practices clearly under the umbrella.
So it's a really wide spectrum of harmful behavior, clearly defined by the state. And the sources highlight that the legal response isn't just one thing, right? It involves both civil remedies and criminal prohibition.
Precisely. We'll be looking at how the sources cover both these parallel tracks. It's not confined to just one area of law. It's a multifaceted legal and policy response.
Okay, let's unpack this then. Let's start with the big picture. How does the criminal law approach domestic abuse? Is there like a single crime called domestic violence?
Well, what's fascinating here, and the sources make this very clear, is that there isn't one single crime specifically labeled domestic violence or domestic abuse in the, traditional sense.
Oh, okay. So how does it work?
Instead, individual acts that constitute domestic abuse are addressed by existing criminal offenses within the general criminal law.
So if there's physical violence, that would just be prosecuted as, say, assault or battery.
Absolutely. The severity of the violence dictates the charge. It could range from common assault right up to the most serious offenses like grievous bodily harm or even murder in the worst cases.
Right.
The sources also mention rape, and it's important to remember the historical context here.
Huh?
A landmark moment cited in the materials was the case of RVR, rape marital exemption, back in 1991.
Ah, yes, I remember that one being significant.
Hugely significant.
Yeah.
It famously abolished the ancient marital exemption for rape, making it unequivocally clear that a husband could be prosecuted for raping his wife. A massive shift in acknowledging abuse within marriage.
A long overdue shift.
Definitely. The sources also list stalking as relevant under criminal law, and very importantly, the more recent standalone offense of coercive control.
Coercive control, that sounds like it maps directly onto the definition we just talked about.
It does. It was introduced by Section 76 of the Serious Crime Act 2015. And this new offense specifically targets that pattern of controlling or coercive behavior, not just individual incidents, which, as you say, is a much better fit for the definition of domestic abuse we started with.
So the criminal law does cover the acts, and the coercive control offense is specifically designed for that pattern. But the sources suggest the criminal law hasn't always been, well, entirely effective on its own. Why is that? What have been the issues?
That's a really important question, and the sources highlight a couple of key reasons for the perceived limitations. Firstly, there can be procedural requirements that, complicate initiating or progressing criminal proceedings.
Legal hurdles.
Yes. The case DPV Little from 1992 is mentioned as a note, suggesting procedural hurdles can be a factor, though perhaps not the main barrier historically.
Okay, legal processes can always be complex. What's the other main reason? It sounds like this one was more significant, historically at least.
The second, and perhaps more historically significant reason the sources highlight, is police reluctance.
Reluctance.
Yes. Traditionally, domestic abuse was often viewed through a lens that saw it as a private family matter, something unsuitable for robust intervention by law enforcement. The sources explicitly state the police traditionally regarded domestic abuse as belonging to the private sphere of family life and unsuitable for law enforcement.
Wow. Seeing it as private rather than a crime, that sounds like a fundamental problem in tackling it effectively.
It was a major historical barrier, yes.
What about the victim's perspective in the criminal process itself? That must be incredibly challenging, I imagine.
That's another critical challenge the sources explore. Victims may be deeply unwilling to go to court and give evidence against their abuser, even if they initially call the police for immediate help.
Why is that? Fear.
Intense fear, often. Fear of reprisals against themselves or their children if they testify. Or they might still hold on to the belief or hope that the violence will stop, maybe after apologies or promises from the perpetrator.
And can they be forced to testify?
Well, technically, a victim can be compelled to give evidence against a spouse in certain circumstances under Section 80 of PACE 1984. That's the Police and Criminal Evidence Act, as qualified by the YJCEA 1999. But, the sources point out, reluctant testimony often lacks cogency. It might not be convincing or hold up effectively in court.
So even if the legal power exists, the practical reality of a victim's fear or reluctance can really undermine the prosecution. It highlights the unique difficulties, doesn't it? Prosecuting crimes within intimate relationships.
Precisely. It underscores the complexities. However, the sources do acknowledge a significant shift in policy and attitude over time.
Things have improved.
The historical reluctance of the police has been widely criticized, and there's been a clear move towards prioritizing these cases. More recently, senior officers, like the former Met Commissioner Sir Ian Blair, explicitly indicated that official policy now strongly favors vigorous prosecution. Home Office circulars have also emphasized the importance of appropriate policing responses.
So the official stance has definitely changed, reflecting a greater understanding, even if those historical attitudes or the inherent victim challenges can still be obstacles in practice.
Yes, there's been progress, certainly in stated policy.
And the sources mention the Domestic Abuse Act 2021. Does that interact with the criminal law aspect we're discussing?
It does. That act, which became law in 2021, builds upon and strengthens the whole legal framework. It provided that comprehensive statutory definition of domestic abuse we discussed right at the start, and introduced various measures, including enhancing existing powers and introducing new ones. It definitely signals that the legal response, including the criminal one, is continually evolving.
Okay. What about dealing with the relationship itself? Its dissolution when violence is involved. The sources mention matrimonial relief.
Yes, for married couples, divorce is discussed as potentially the most appropriate long-term response to a violent spouse, as it formally ends the relationship.
Though sadly, the violence doesn't always end with the relationship, does it?
Unfortunately not. The sources note that violence and harassment can, sadly, continue even after divorce or formal separation.
What else is mentioned under matrimonial relief?
The sources also briefly touch upon judicial separation under Section 17 of the Matrimonial Causes Act 1973, the MCA 1973. This allows couples to formalize their separation through the court without actually ending the marriage itself.
And for civil partners?
There's an equivalent separation order under Section 56(1) of the Civil Partnership Act 2004, the CPA 2004. These remedies use the same facts or grounds as divorce but don't require proving the marriage or partnership has irretrievably broken down, which can sometimes be simpler. And the court has powers to make financial provision and custody orders in these cases too.
But it sounds like the sources indicate these aren't the primary legal tools used for immediate protection from violence, especially concerning where people live.
That's correct. The sources state that judicial separation and separation orders have largely been overtaken by the procedures we're about to dive into now. Specifically, protective orders designed precisely to regulate the occupation of the family home following violence or the threat of violence.
Okay.
These are seen as more direct and immediate responses to the danger posed by the living situation itself.
Right, here's where it gets really interesting. The sources focus heavily, and I mean heavily, on the Family Law Act 1996. Let's call it the FLA 1996. What did this act actually do, and what are the main protective tool that provides?
The FLA 1996, specifically Part 4, was a really significant, almost foundational reform in this area of law. As the sources explained, before this act, the law dealing with domestic abuse and who gets to live in the home was incredibly complex. It was fragmented, spread across multiple different statutes, different courts. It was a bit of a mess.
Sounds confusing for someone needing help quickly.
Exactly. So the 1996 Act aimed to bring it all together, creating what the sources call a comprehensive and unified code to deal with protection against domestic abuse and disputes about home occupation. The goal was simplification, making the law more accessible and coherent.
That sounds like a much-needed change. What are the main types of relief, the key tools it provides for victims, then?
The Act provides two primary forms of civil relief, specifically targeted at the effects of domestic abuse. Firstly, there's a non-molestation order.
Non-molestation, what does that do?
This is an order directed at the respondent, the alleged perpetrator, and it's designed to restrain them from interfering with or molesting the applicant. It's essentially about personal protection, preventing harassing or abusive behavior directed at the person.
Okay, so a non-molestation order is about stopping unwanted personal contact or harassment. What's the other main tool? You mentioned it relates to the home.
The second primary tool is an occupation order. This is an order specifically about regulating who can live in the family home.
Regulating occupation.
It can do various things. It can enforce a right to occupy for the applicant, perhaps require the respondent to leave the home entirely, or even exclude the respondent from a defined area around the home. It's focused squarely on the living arrangements.
Got it. So non-molestation is about protecting the person. Occupation is about protecting their right to live safely in the home. Now, the sources spend a lot of time breaking down occupation orders, and it seems the Act draws some pretty important lines based on people's connection to the home and their relationship status.
Precisely. This is an absolutely critical distinction running throughout Part 4 of the FLA 1996. The Act very carefully distinguishes between different categories of potential applicants based on two main factors.
Okay, what are they?
Firstly, whether they have a property interest in the dwelling house, like ownership or tenancy, or possess statutory home rights. Secondly, whether they are spouses or former spouses versus cohabitants or former cohabitants.
Right, married versus unmarried, basically, and whether they own or rent the place.
In essence, yes. Understanding these different categories and the specific statutory sections that apply to each is absolutely key to understanding how occupation orders work and who is entitled to what level of protection under the Act.
Okay, let's dive deep into these occupation orders under the FLA 1996 Part 4 then. We need to follow the structure and the sections as they're laid out in the sources, because it sounds like the tests and what's available really vary.
We absolutely do. We need to break this down by the different sections covering the applicant types, just as the source material does, because the tests and the orders available differ significantly depending on who you are and what your connection to the property is.
Let's start with Section 33. Applicants with estate interest or home rights. Who does this section cover? Who fits into this category?
Okay, Section 33 applies to someone who already have a legal or equitable interest in the property that gives them an entitlement to occupy it.
So someone who owns it or is a tenant?
Exactly. Think of it as having a formal legal connection, like owning the property outright, being a joint owner, or being a named tenant on the lease agreement. It also covers someone who has statutory home rights.
Home rights. What are those again?
Section 30 of the FLA 1996 defines home rights. Essentially, if you are the spouse or civil partner of someone who owns or has a legal right to occupy the home, you gain specific statutory home rights in that property. These include a right to occupy it or enter it, even if your name isn't on the title deeds or the lease.
Ah, okay. So it protects spouse civil partners even if they aren't the legal owner tenant.
Correct. And importantly, for Section 33 to apply, the respondent, the person the order is sought against, must also be entitled to occupy the property, either through ownership, tenancy, or their own home rights.
So this covers people with a formal legal connection to the property, either directly or through marriage civil partnership, where the other party also has a right to be there. What powers does the court have under Section 33 once it decides to make an order?
The court has a really wide range of powers under this section. Section 33 gives them a lot of flexibility to tailor the order to the specific circumstances, which are often very complex in these situations.
Like what?
The court can enforce the applicant's existing right to occupy, require the respondent to permit the applicant to enter and remain in the home, regulate the occupation rights of both parties, like saying who uses which rooms, suspend, prohibit, or restrict the respondent's own right to occupy, restrict or even terminate the respondent's home rights, require the respondent to leave the dwelling house or a specified part of it, or even exclude the respondent from a defined area around the home.
That's a very comprehensive list of powers, from regulating how they share the space to completely excluding one party.
Exactly. The sources explicitly state the flexibility this offers. For example, allowing the court to order the perpetrator's exclusion or require them to let the applicant back into the home if they've been forced out.
And the sources mention these orders under Section 33 end if the marriage or civil partnership ends or if the other spouse dies.
Yes, that makes sense if the applicant's right to apply under Section 33 was based on those home rights derived from the marriage or civil partnership. Once the relationship ends legally, those specific home rights cease.
Okay. Now, what factors must the court consider when deciding whether to make an order under Section 33?
Under Section 33(6), the court must consider all the circumstances of the case. The sources list key factors specifically called out in the legislation: the housing needs and resources of the parties and any relevant children, the financial resources of the parties, the likely effect of any order or not making an order on the health, safety, or well-being of the parties and any relevant children, and crucially, the conduct of the parties in relation to each other and otherwise.
Conduct in relation to each other and otherwise. What does that mean?
It means the court looks at their behavior towards each other, obviously, but also potentially other conduct if it's relevant to the housing situation or the reasons for the application. It's quite broad.
That seems like a thorough assessment, covering practical needs, money, well-being, behavior. But the sources highlight a really crucial specific test under this section, the mandatory balance of harm test in Section 33(7). Can you break that down for us? It sounds pivotal.
This is absolutely vital, yes.
Yeah.
Especially for these Section 33 applicants who have that property interest or home rights. Section 33(7) introduces a specific mandatory test that the court must apply. It directs the court to consider whether the applicant or any relevant child is likely to suffer significant harm that is attributable to the conduct of the respondent if the order is not made.
Okay, step one. Is the applicant or child likely to suffer significant harm because of the respondent's conduct if no order is made?
Exactly. Significant harm attributable to the respondent. If, having considered that, it appears to the court that this is likely, then the court must make an order.
Must no discretion.
It must make an order unless there's a crucial caveat, a balancing act.
Okay. What's the unless?
Unless it appears that the respondent or any relevant child, and this could include children living with the respondent from another relationship, for example, is likely to suffer significant harm if the order is made, and that the harm likely to be suffered by the respondent or that child is likely to be greater than or as great as the harm which is likely to be suffered by the applicant or their relevant child if the order is denied.
Wow. Okay, so the court has to weigh the likely significant harm to the applicant child if no order is made against the likely significant harm to the respondent child if the order is made. A direct comparison of harms.
Precisely. The court must undertake what the sources describe as a careful analysis of the respective harms alleged by both applicant and respondent. It's a detailed weighing exercise.
And what happens if the applicant wins that balancing act?
The sources emphasize that if the applicant passes this mandatory test, meaning their likely significant attributable harm is not outweighed by the respondent's potential greater or equal significant harm, then the court has NAO discretion. It must make an occupation order under Section 33.
That's incredibly powerful. It forces the court's hand when significant harm is established and isn't outweighed. What if the applicant doesn't pass that specific S337 test?
Good question. If the test under Section 33(7) is not passed, maybe the harm isn't deemed significant, or it isn't attributable to the respondent's conduct, or it is outweighed by the respondent's potential harm. The court still retains discretion to make an order based on the broader Section 33(6) factors we discussed earlier: needs, resources, conduct, well-being, etc.
I see. So S3337 is a mandatory route if the test is met, but even if it's not, the court can still choose to make an order based on the general circumstances under S336.
Exactly, but the Section 33.7 balance of harm test, because of its mandatory nature, is often the first thing the courts consider. If it applies, it dictates the outcome.
This mandatory test sounds like a really strong protection mechanism. Let's look at the case law the sources use to illustrate how Section 33 works in practice, particularly this balance of harm. First up, BVB from 1999.
Right, BVB.
Yeah.
In this case, the Court of Appeal applied this very balance of harm test. The situation was, wife, a joint tenant, left the family home with their baby due to the husband's violence. The husband stayed in the home with his 6-year-old son from a previous relationship.
Okay, a complicated family setup.
Very. The county court judge initially granted an occupation order for the wife and baby, which meant removing the husband and his son. However, on appeal, the Court of Appeal overturned that. They allowed the husband's appeal.
Why?
They concluded that the 6-year-old son living with the husband was likely to suffer significant harm if the order was made because they'd have to leave their home. And they felt, applying the Section 33.7 balance of harm test, that the son's needs at that moment outweigh those of the wife and the baby.
So they balanced the harm to the children.
Yes. The availability, or rather the limitations, of rehousing options from the local authority for both parties were also considered as part of the overall circumstances. The duty to rehouse the husband and son was seen as only temporary compared to the broader duty towards the wife and baby. Ultimately, the wife didn't succeed on the mandatory balance of harm test, and the court also declined to exercise its Section 33.6 discretion in her favor. So, BVB, repeat the case name, BVB, is a key example of the court carefully weighing the likely significant harm to the children of both parties under that crucial Section 33.7 test.
That case really highlights the incredibly difficult balancing act the courts face, especially when children from different relationships are involved and housing is scarce. The sources then bring in some historical context again with Chalmers v. Johns, also from 1999.
Yes, Chalmers v. Johns. This one's interesting because it shows how the courts initially grappled with the FLA in 1996, sometimes perhaps continuing a more cautious approach that existed before the act came in. Well, the sources explain that the old ouster orders removing someone from their home, were often viewed as extremely serious. The word draconian is used.
Draconian, a very strong word.
It is, and they were seen as only appropriate in exceptional cases, particularly when they involved overriding someone's existing property rights, like ownership or tenancy. Chalmers v. Johns seemed to continue this view. The Court of Appeal advised caution in making occupation and exclusion orders, especially those overriding proprietary rights early on, unless that mandatory balance of harm test under Section 33.7 clearly favored the applicant.
So the judgment was still quite hesitant about kicking someone out of their own property.
It seems so. The sources note that the FLA 1996 actually hoped to change this perception of ouster orders as always being draconian, to make them a more standard tool for protection. But Chalmers v. Johns suggested that the older, more cautious attitude persisted, at least initially, amongst some judges. Repeat case name, Chalmers v. Johns.
So, even with the new act specifically designed to provide protection, removing someone with property rights was still seen by some judges as a big draconian step. What about ReY children occupation order from 2000? Does that case shed more light on this?
ReY is another important illustration. It touches on both the draconian label and that key requirement for harm to be attributable to the respondent under S337.
What happened in ReY?
In this case, unusually, the initial occupation order was made in favor of the husband, who had health issues and a disability. The first judge felt the Section 33.37 balance of harm test was in his favor. However, on appeal, the court overturned this.
On what grounds?
They held there was no evidence that the harm suffered by the husband was actually attributable to the wife's conduct. That's a necessary element of the Section 33.7 test. Remember, the harm might have been happening, but it wasn't caused by her actions.
Ah, the attribution point.
Exactly.
Yeah.
The appeal court also reinforced the idea that evicting a co-owner from a matrimonial home is indeed a draconian remedy. They said it should be used as a last resort and not in order to be made lightly.
Yeah.
The court even suggested perhaps the issue should have been framed differently, maybe, about whether the home could be divided or shared with strict rules rather than outright eviction. So, ReY, let's repeat that. ReY reiterates the draconian label and strongly highlights the need for the potential significant harm under Section 33.7 to be attributable to the respondent's conduct, not just something happening concurrently.
Right. The harm has to be a consequence of their actions. That distinction between effect and intent seems really important for protecting victims. Now, GVG, Occupation Order, Conduct, also from 2000, apparently tells us something crucial about the relationship between the mandatory test and the court's discretion under Section 33.
Yes, GBG is a key case for clarifying how Section 33 actually operates in practice. It confirms that if the court finds, under Section 33(7), that the applicant or a child is likely to suffer significant harm attributable to the conduct of the respondent, then the court must make an occupation order unless the respondent's harm outweighs it.
The mandatory part.
Correct. But crucially, GVG clarifies that even if the Section 33(7) mandatory test isn't met, maybe the harm isn't significant enough or isn't attributable, the court still has discretion under Section 33(6) to make an order based on those broader factors like needs, resources, and health safety.
So it confirms the two routes, mandatory under S43(7) if met, discretionary under SB336 otherwise.
Precisely. GVG also provides important guidance on what harm attributable to the conduct of the respondent actually means under Section 33(7). The court held that the important factor is the effect of the conduct upon the applicant or children rather than the intention of the respondent.
The effect, not the intent. That sounds vital.
It is. So if the respondent's actions cause significant harm, the fact that they didn't necessarily intend to cause that specific harm doesn't automatically mean it isn't attributable to their conduct for the purposes of the test. While lack of intent might be a relevant consideration under the broader Section 33(6) discretion, the focus for the mandatory test is the impact on the victim. Repeat the case name, GVVG.
That focus on the effect on the victim seems absolutely central to providing protection. Now, Grubb v. Grubb from 2009 sounds like another case dealing with this intersection of occupation orders and property rights, particularly that draconian label.
Grubb v. Grubb is indeed a fascinating case. It revisited the draconian nature of ouster orders, but this time more in the context of the court applying its discretion under Section 33(6), where the mandatory Section 33(7) test needing significant harm wasn't necessarily the main focus.
What were the facts?
The wife applied for an occupation order under Section 33(6). The husband appealed against being ordered to leave what the sources specifically refer to as his ancestral home.
Ancestral home. Sounds like high stakes, emotionally and financially.
Definitely. He argued the judge hadn't fully recognized the seriousness of removing him from a home with such historical significance to his family. However, Wilson L.J. in the Court of Appeal rejected the husband's appeal.
Why so? If it was his ancestral home?
Wilson L.J. acknowledged that an occupation order is always serious, and yes, can be particularly serious when it relates to someone being removed from an ancestral home. Repeat phrase, ancestral home. However, he stated that its greatest level of seriousness, the reason it's often called draconian, is when the spouse being removed has no alternative accommodation available.
The availability of somewhere else to live.
Exactly. In Grubb v. Grubb, the husband did have other properties readily available on the estate and, quote, massive resources to fund comfortable accommodation elsewhere. Since immediate separation was deemed necessary and beneficial for the family, and the husband had failed to propose any alternative arrangements for the wife's accommodation, ordering the husband to leave his ancestral home was seen as the only practicable way to achieve that needed separation.
So even though it was an ancestral home and a serious order, the fact the husband had suitable alternative accommodations significantly influenced the court's view of how truly draconian the order was in those specific circumstances. It allowed the court to exercise its discretion under Section 33.
Precisely. Grubb v. Grubb shows how the specific factual context, including the availability of alternative housing for the person being excluded, really informs the court's exercise of discretion under Section 33(6). It suggests that while property rights and the draconian label are relevant, they are not absolute barriers, especially when safety or necessary separation is required and alternative accommodation exists for the respondent. Repeat case name, Grubb v. Grubb.
The sources also mentioned two more recent cases, Dolan v. Corby from 2011 and Riel Occupation Order from 2012. What do these add to our understanding?
Yes, these cases seem to indicate a potential evolution, maybe, in how courts are using Section 33, particularly that discretionary power under Section 33(6). The sources note that recent cases like Dolan v. Corby and Riel suggest courts might be increasingly willing to exercise their discretion under Section 33(6) to grant occupation orders without necessarily requiring proof of physical violence.
So potentially covering other forms of abuse.
Potentially, yes. This is significant because it means other forms of abuse, Psychological, emotional, controlling behavior could potentially justify an order under the discretionary power, even if they don't meet the high threshold of significant harm attributable to conduct needed for the mandatory Section 33(7) test.
But still seen as draconian.
Yes, the sources still caution that orders are still generally considered draconian and that physical violence might still be the kind of conduct needed to meet the high threshold for the mandatory Section 33(7) balance of harm test. But the discretionary route under S336 seems potentially broader. Repeat case names: Dolan v. Corby, Riel.
So the courts are balancing rights, the draconian label and property rights remain important considerations, but maybe the application of the discretionary power is evolving to cover non-physical abuse more readily. Based on all this Section 33 case law, what do you think about that tension between protecting the victim and respecting property rights? The sources pose this as a discussion point. How are the courts navigating this? It seems like a real tightrope walk.
It absolutely is a significant point of debate, and the sources rightly highlight it. The case law clearly shows the courts grappling with this inherent tension. On one hand, you have that clear judicial reluctance, seen in cases like Chalmers v. Johns and Re to lightly override someone's established proprietary rights. Removing someone from their home, especially if they own it or are a named tenant, is viewed as a serious step, a draconian remedy, a last resort.
Yeah, but
On the other hand, the FLA 1996 itself, particularly that mandatory Section 33(7) test, is explicitly designed to prioritize protection from significant harm where it's attributable to the respondent's conduct. If those statutory conditions are met under Section 33(7), the court must make an order. It compels them to override property rights if necessary to prevent that harm.
And Grubb v. Grubb showed they will use discretion too, even with ancestral homes.
Exactly. Grubb v. Grubb shows that even with significant property rights, the court can and will make an order under its discretionary powers, Section 33(6), if it's necessary for safety and separation, especially if alternative accommodation mitigates that draconian impact for the respondent. And those cases, Dolan v. Corby and Riel, suggest a potential broadening of that discretionary power to include non-physical abuse.
So is the trend towards prioritizing safety over property rights?
I think the case law demonstrates that while property rights remain a serious consideration, particularly when alternative accommodation is limited, the Act provides, and the courts are exercising, powers that can and do override those rights when harm or necessary separation is the issue. The Act itself tried to move away from property rights automatically trumping protection. The debate posed in the sources is whether these decisions show a discernible trend towards prioritizing victim safety. I'd say the trend in exercising the statutory powers seems to be towards enabling the prioritization of safety when the conditions are met, even if it means interfering with property rights. Whether that's entirely desirable from all perspectives is a philosophical debate, but the law allows it, and courts seem increasingly willing to use it.
That's a great summary of that complex tension. Not a simple answer, but the trend seems to be towards enabling safety when needed. Okay, let's move to the next category for occupation orders. Section 35. Former spouse with no existing right. This covers a different scenario regarding connection to the property, right?
Yes, this section covers a specific situation. The applicant is a former spouse or civil partner, meaning the marriage or partnership has legally ended through divorce or annulment, A&E. They do not have a legal or beneficial entitlement to the property that gives them a right to occupy it. The respondent, however, is entitled to occupy.
So think of a divorced person whose ex-partner owns or rents the house they used to share, and the applicant isn't on the deeds or lease anymore.
Exactly that scenario.
What kind of orders can the court make under Section 35 for these former spouses without property rights?
The court can grant the applicant the right not to be evicted or excluded from the dwelling house by the respondent for a specified period. Or, if the applicant isn't currently living there, the court can grant them the right to enter and occupy for a specified period. It's essentially about granting or protecting a temporary right to occupy where none formally exists post-divorce based on need and the circumstances.
The sources describe a two-stage process for the court under this section. Why two stages here?
Yes, this two-stage process is important because, unlike Section 33 applicants, these former spouses don't have an inherent property right or current home right to occupy based on their status or ownership. So the court first has to decide whether to grant them any occupancy rights at all, and then if it does, how to regulate those rights.
Okay, stage one.
Stage one is the declaratory stage. The court must first decide whether to grant the applicant any occupancy rights in the first place. This is a purely discretionary decision. When making this decision, the court considers factors listed under Section 35(6). This list includes all the general Section 33's factors: housing, financial needs, health, safety, conduct for parties and children. Plus, some factors specific to former relationships.
Like what?
Things like the length of time since they stopped living together, the length of time since the marriage civil partnership was dissolved or annulled, whether there are pending financial remedy proceedings, like sorting out money and property after divorce, any pending applications under the Children Act 1989 for property provision for a child, and any pending proceedings about the legal or beneficial ownership of the property itself.
So the court looks at the general practical factors and factors relevant to the history and the legal unwinding of the former relationship. If they decide at stage 1 that yes, it's appropriate to grant some occupancy rights, what happens at stage 2?
Then comes stage 2, the regulatory stage.
Yeah.
If the court grants occupancy rights at stage 1, it then decides whether to make a regulatory order, using powers similar to the wide range under Section 33, regulating occupation, requiring the respondent to leave, excluding them, etc. And crucially, at this second stage, the court must apply the balance of harm test, just like under Section 33(7).
The mandatory test comes back in for former spouses at stage 2.
Yes. If that test is met, meaning the applicant or child is likely to suffer significant harm attributable to the respondent if a regulatory order is not made, and that harm isn't outweighed by the respondent's potential harm if it is made, the court must make a regulatory order. If the test isn't met, the court still retains discretion to make a regulatory order after considering all the circumstances listed back in Section 35(6)(a).
So for former spouses without a property right, getting any right to occupy stage 1 is discretionary, based on broad factors or relationship history. But if they get that initial right and the mandatory harm test is met, stage 2, a regulatory order must be made, similar to Section 33. What about the duration of these orders under Section 35? How long do they last?
Orders under Section 35 are limited. They are made for a specified period, which cannot exceed 6 months initially. However, they may be extended on one or more occasions for a further specified period, not exceeding 6 months each time.
So 6 months, but potentially repeatable extensions. Okay, that covers former spouses with no property right. Now, what about the equivalent category for unmarried partners? Section 36. Former cohabitant with no existing right.
This section mirrors Section 35, but it applies specifically to cohabitants or former cohabitants who do not have a legal or beneficial interest in the property that entitles them to occupy it, where the respondent does have such an entitlement.
So an unmarried partner who lived there but isn't on the deed or lease, and the relationship has ended or is in crisis, and the other partner is the owner-tenant, is it the same two-stage process as for former spouses?
Yes, it's also a two-stage process, declaratory, then regulatory.
Stage 1, deciding whether to grant any rights.
Stage 1, deciding whether to grant any occupancy rights at all, which is discretionary, involves the court considering factors listed under Section 36. This list includes the general Section 33(6) factors: housing, financial, health, safety, conduct, plus factors specific to cohabitation situations.
What kind of factors are specific to cohabitants?
Things like the nature of the parties' relationship, the length of time they live together as husband and wife, that's the phrasing in the act, whether there are or have been any children for whom both parties have parental responsibility, the length of time since they ceased living together, and any pending proceedings.
And the sources mention something about the court having to consider the lack of marriage commitment.
Yes. Section 41 of the FLA 1996 specifically directs the court, when considering the nature of the parties' relationship for cohabitants under Section 36, to have regard to the fact that they have not given each other the commitment involved in marriage.
Okay, so that difference in legal status is explicitly brought into the decision-making at Stage 1. Now, what about Stage 2? Deciding on the regulatory order once occupancy rights are declared at Stage 1.
This is where there is a crucial difference compared to spouses and former spouses under Sections 33 and 35, and even Section 37, which we'll get to shortly. When considering whether to make a regulatory order for cohabitants under Section 36, the mandatory balance of harm test does not apply.
It doesn't apply at all for cohabitants under S.36.
No. While the harm questions the likelihood of significant harm to the applicant or child are still considered by the court, they are contained within the list of other factors the court must consider under Section 36. The statutory obligation to make an order if the harm test is met does not apply to Section 36 applicants.
So what does that mean in practice?
It means that all orders under Section 36 are discretionary. There are simply no circumstances under this section where the court must make an order. even if significant harm to the applicant or child attributable to the respondent is proven and isn't outweighed.
Wow. That is a really significant difference based purely on relationship status. Even if significant harm is likely to the cohabitant or a child, clearly caused by the respondent, the court retains discretion and is never compelled to make an order.
Yes, that is precisely what the sources highlight as a key difference in the statutory framework for Section 36 applicants. The court must consider the potential for harm, yes, but the mandatory obligation to act if the balance of harm test is met is absent for cohabitants without a property right. Discretion rules.
And what about the duration of orders under Section 36 for cohabitants?
Orders under Section 36 last for a maximum of 6 months initially and may only be extended once for a further 6-month period.
Only one extension.
Yes, that's another difference compared to former spouses under Section 35, where extensions are potentially unlimited in number. So, a maximum potential duration of 12 months in total for cohabitants under Section 36.
So, for cohabitants without property rights, orders are always discretionary. No mandatory harm test applies, and the maximum duration is shorter, one extension only. That distinction based on marital status is a major feature of the Act, isn't it? It leads directly to the source's question. List the differences between the treatment of spouses, former spouses, and cohabitants, former cohabitants. And should protection from violence depend upon relationship status?
Based on the sections we've just walked through, the key differences are stark. For those with property home rights, Section 33, or disentitled former spouses at the regulatory stage, Section 35, Stage 2, the mandatory balance of harm test applies. If that test is met, the court must make an order. For disentitled cohabitants, former cohabitants, Section 36, that mandatory test does not apply. All orders are discretionary, even if significant harm is proven.
And the duration difference, too.
Yes. The maximum duration of orders is different. A limited total duration, 6 months plus one 6-month extension, so 12 months max, for cohabitants under Section 36, compared to potentially multiple extensions for former spouses under Section 35. Plus, remember, Section 41 explicitly directs the court to consider the lack of marital commitment for cohabitants.
And the big question then, should this distinction exist? Should your protection from violence, your right to a safe home, depend on whether you had a marriage certificate?
That is, as the sources imply, a significant point of debate and potential criticism of the Act. You could strongly argue that the impact of violence, the need for safety, is the same regardless of marital status. The harm suffered by a cohabitant and their children is no less real or significant. So why should the legal tools, particularly the mandatory harm test and the duration of orders, be less protective?
What's the counterargument? Why might the law draw this line?
Well, the counterargument, or perhaps the rationale behind the Act, is that it attempts to balance various interests. Protection of proprietary rights is one, and reflecting the different legal commitments people choose to enter into is another. Marriage creates specific legal obligations and rights regarding property and finance that cohabitation traditionally does not. The Act reflects this legal difference. But the consequence, the distinction in the level of protection offered, especially regarding the mandatory harm test and duration, is undeniably a significant and sometimes controversial feature of the law as set out here.
It really highlights that the law isn't just about preventing harm in isolation. It interacts deeply with established legal concepts of property and relationship status. Okay, let's quickly cover the last two categories for occupation orders. What about situations where neither spouse is entitled, Section 37, where neither party has a formal property right?
This section applies where neither the applicant nor the respondent has a legal or beneficial interest in the property, so neither owns nor formally rents it. Examples given in the sources include squatters or maybe adult children living with parents where neither child is the owner or tenant.
What powers does the court have under Section 37 in these situations?
Similar regulatory powers to Section 33 adapted for this scenario, requiring the applicant to enter or remain, regulating occupation, requiring the respondent to leave, excluding the respondent.
And the test the court applies here, does the mandatory harm test apply even if neither is entitled?
Yes, interestingly, for disentitled spouses under Section 37, the court is required to apply both the Section 33 SC6ers and Section 33(7), the mandatory balance of harm test.
Really? Even with no property rights involved?
Yes. And importantly, the sources state that if the balance of harm favors the applicant under Section 33(7), the court is obliged to exercise at least one of its regulatory powers under Section 37. This is a key similarity to Section 33, entitled spouses, and key difference from cohabitants in the same non-entitled position, as we'll see next.
So, even if neither spouse owns or rents the place, if the mandatory harm test is met, the court must make an order. That makes the strong protection based on the mandatory test available to spouses regardless of their property connection, as long as neither is entitled. What's the duration for Section 37 orders?
Maximum 6 months initially, extendable on one or more occasions by up to 6 months each time, similar to S.35.
And finally, Section 38. Neither cohabitant, former cohabitant titled, the equivalent for unmarried partners with no property right.
This section applies to cohabitants or former cohabitants where neither party has a legal or beneficial interest in the property they lived in.
Are the provisions similar to Section 37 for spouses?
Yes, the powers available to the court are similar to Section 37. The court considers the Section 33(6) factors, adapted, and the harm questions, as it does for all occupation order applications. However, and this is another key difference reinforcing the pattern, the court retains discretion whether or not to make the order, even if the balance of harm factors might suggest significant harm is likely to the applicant or child attributable to the respondent.
So again, no mandatory order for cohabitants.
Correct. As with Section 36, the mandatory application of the balance of harm test does not apply here under Section 38. This again reinforces that difference in treatment based purely on relationship status. All orders for cohabitants under S.36 and S.38 are discretionary.
And the duration for these disentitled cohabitants under Section 38.
Maximum 6 months initially, and the number of extensions is limited to one, just like S.36, and again, more limited than for disentitled spouses under Section 37.
Wow. That really is a lot of detail and very subtle but absolutely crucial differences based on relationship status, spouse versus cohabitant, and property rights, entitled versus disentitled. It fundamentally shapes the level and duration of protection available through occupation orders. It makes understanding those section numbers 33, 35, 36, 37, 38 really important.
It does. You need to know which section applies to your scenario.
The sources pose another question here which helps summarize. Why is an occupation order regarded as first aid rather than a long-term solution?
That's a great question, and it helps consolidate our understanding of their purpose. Given the limited duration of many of these orders, particularly for cohabitants, with that maximum of 12 months total under S.36 and S.38, but even for spouses where the initial order is often for a defined period before needing extension, it seems clear they are primarily designed to provide immediate, crucial breathing space, safety in the short term.
Right. They get the perpetrator out or get the victim back in safely, creating a period of calm that allows them time to make longer-term arrangements.
Exactly. They are intended for immediate protection, to create safety by regulating who can be in the home right now. They interrupt the cycle of abuse by physically separating the parties or controlling their access. But they aren't usually intended as a permanent housing solution for the victim.
So what happens next?
Often they need to be combined with other remedies. Pursuing divorce and financial settlements, which might include property adjustment orders giving one part of the house long-term. Or, very commonly, applying for public sector rehousing from the local authority or a housing association. The occupation order provides the first aid. It addresses the immediate physical danger in the home, but further steps are typically needed for a stable, long-term housing solution.
That makes perfect sense. They stop the immediate crisis by time, but don't solve the underlying housing need permanently.
Precisely. They buy that crucial time and safety.
Okay, let's turn now to the other key order under the FLA 1996, the non-molestation order. This is about personal protection from unwanted contact or harassment, distinct from the home itself. Who can apply for one of these under Section 42?
The sources are very clear on this. Only persons who are associated with the respondent can apply for a non-molestation order. And associated isn't just a general term used loosely here. No, it's a specific legal concept defined exhaustively in Section 62(3)-6 of the Family Law Act 1996. It's a closed list. If your relationship with the respondent doesn't fall into one of these specific categories, you can't apply for a non-molestation order under Section 42, repeat term, associated persons.
Okay, so you have to be associated. Who exactly falls into this category of associated persons? The sources list quite a few categories, it seems, designed to cover different types of relationships.
Yes, the list is designed to be broad enough to cover many situations where domestic abuse might occur. I'll list the main categories as they appear in the sources. It's good to know these. 1. Present and former spouses. 2. Civil partners or former civil partners. 3. Present and former cohabitants, and that includes opposite sex or same-sex couples. 4. People who live or have lived in the same household, other than as an employee, tenant, lodger, or boarder, so people who are part of the family unit living together. 5. Relatives, This is quite broad. Parents, children, siblings, grandparents, grandchildren, uncles, aunts, nephews, nieces, first cousins, and also step-relatives and in-laws. 5. Relatives. This is quite broad. 6. Engaged or formerly engaged couples. 5. Relatives. This is quite broad. 7. Parties to a civil partnership agreement, even if the partnership hasn't actually been formed yet. 8. This one's interesting. Persons who have or have had an intimate personal relationship with each other, which is or was of significant duration.
Ah, that sounds like it could catch relationships that don't fit neatly into the other boxes. Yeah.
Exactly. It's a potentially broad category designed for relationships that were significant but maybe didn't involve marriage, cohabitation, or being related.
Okay, what else?
9. Parents of a child or those having parental responsibility for a child. This applies regardless of their relationship with each other. 10. And finally, parties to the same family proceedings, other than proceedings under Part 4 of the FLA itself.
That is a comprehensive list. It covers a lot more than just current spouses or cohabitants. It really seems designed to cover most close family or intimate relationships where abuse might occur. The sources even mention a recent case that clarifies the limits of this definition, right? Confirming it's not infinitely expandable.
Yes, the case MVD from 2021, repeat case name, MVD. This case confirmed that a step-nephew did not fall within the specific terms of the definition of an associated person under Section 62.3. It serves as a reminder that while the list is broad, it is a defined list, and the court will look closely at whether the specific relationship fits one of the statutory categories.
Okay, so you have to be associated to apply for a non-molestation order. But what exactly does molestation mean? You mentioned earlier the Act itself doesn't define the term.
That's absolutely correct. The FLA 1996 uses the term molestation in Section 42, but whether deliberately or not doesn't provide a statutory definition. This has been left to the courts to interpret over the years.
So what have the courts said?
The sources cite an early case, CVC, non-molestation order, jurisdiction from 1998, repeat case name, CVC. In that case, the court held that the term implies deliberate conduct, which is aimed at a high degree of harassment, so as to justify intervention by the court. So serious, deliberate harassment.
Has that definition evolved?
More recently, in RE-ET, a child, non-molestation order from 2017, the Court of Appeal, specifically McFarlane LJ, reviewed the existing case law on what constitutes molestation. Repeat case name.
What?
RE-ET. He noted that family judges have consistently avoided a precise definition.
Why avoid defining it?
Because it's a term that needs flexibility to apply to all sorts of different factual situations. McFarlane LJ cited earlier judicial comments, like Ormrod LJ and Horner v. Horner back in 1983, repeat case name. Horner v. Horner, who described it as applying to any conduct which can properly be regarded as such a degree of harassment as to call for the intervention of the court. He also referenced Hale LJ in a different CVC case in 2001, repeat case name. CVC, who held it covered conduct calculated to cause alarm and distress.
So still focusing on harassment, alarm, distress.
Yes. And the key takeaway from McFarlane LJ's review in RE-T, remember RE-T, is that courts should be very wary of trying to offer further precision or a rigid definition. Instead, they should rely on good sense and judgment on a case-by-case basis to determine if the particular conduct in question amounts to molestation that warrants the court stepping in under the Act.
Okay. So no single strict definition, but courts look for a pattern or level of behavior that causes significant harassment, alarm, or distress, justifying the court's protective powers. It's about the impact and the need for intervention.
Exactly. Good sense and judgment on the facts.
That lack of a strict definition gives courts necessary flexibility, but, as you say, relies heavily on judicial judgment. Let's look at the non-molestation case law illustrations provided in the sources to see how this has been applied.
Okay. The sources give several examples.
Yeah.
CVC from 1998, which we just mentioned regarding the definition, repeat case name. CVC actually provides an example of conduct that was not considered molestation under the Act, despite being pretty objectionable.
What happened there?
The ex-wife got newspaper stories published about her relationship with her ex-husband.
Mm.
The court saw this as an invasion of privacy, certainly, but held it was not molestation under the Act because it lacked that specific element of deliberate conduct aimed at a high degree of harassment justifying intervention within the specific context of the non-molestation provisions.
So, unpleasant, yes, but not meeting the legal threshold for molestation under FLA 1996. What other cases?
Then there's Banks v. Banks. Repeat case name. Banks v. Banks. Here, a husband applied for a non-molestation order against his wife. Her problematic behavior stemmed from a diagnosed mental condition. The court refused the order, feeling that since she couldn't control her actions due to her illness, an order would serve no useful purpose in restraining her.
Interesting. So the court considered the purpose and potential effectiveness of the order, not just the behavior itself.
Yes, it's not just about classifying behavior, but whether the order can actually provide protection. The sources also discuss GVF from 2000. Repeat case name. GVF. This case is particularly interesting as it concerned the definition of associated persons.
Back to who can apply, what was the issue?
The applicant and respondent had had an intimate relationship and divided their time between their respective flats, but the applicant admitted that, strictly speaking, we do not live together. The first court said they weren't associated under the category of living in the same household.
But they appealed.
Yes. And on appeal, the court took what was described as a purposive construction approach to the definition of associated persons in Section 62. They said the court shouldn't narrowly construe the categories to exclude borderline cases because Part 4 of the FLA 1996 was designed to provide swift and accessible protective remedies to victims.
Looking at the purpose of the act again.
Exactly. Since the criteria were met based on the substance of their relationship, they fell into that other category, remember, of having had an intimate personal relationship of significant duration. The court shouldn't refuse jurisdiction just because their living arrangements weren't strictly cohabitation. Repeat case name. GVF.
GVF is really interesting then. It shows the court looking at the spirit and purpose of the act, providing protection rather than sticking to overly rigid interpretations of the definitions. It links back to your earlier point about relationship status and living arrangements. Based on GVF and that explicit inclusion of persons who have had an intimate personal relationship of significant duration category, what about this scenario from the source? Two men, Alistair and Tony, were in a committed 5-year relationship, saw each other regularly, but never formally lived together. If Alistair became violent and abusive, could Tony apply for a non-molestation order under Section 42?
Absolutely, yes.
Yeah.
Based on that purposive approach in GVF and the explicit inclusion of that category in Section 62(3), intimate personal relationship of significant duration, Tony could almost certainly apply. Well, the court would look at the substance and duration. A 5-year committed relationship. That certainly sounds intimate and of significant duration. The fact they hadn't formally lived together wouldn't automatically exclude them from being associated under that specific category, as GVF and the wording of 623 make clear. It supports the idea that protection isn't solely dependent on formal status or sharing a residence. The reality of the relationship can be enough if it fits one of the statutory categories.
That's a really important point. It extends the reach of non-molestation orders to cover significant relationships, even without cohabitation. The sources also note that a child can apply for these orders.
Yes, but only with the permission of the court. This is under Section 43. The court grants leave based on whether the child has sufficient understanding to make the application. It provides a route for protection directly for children, acknowledging they can be victims, but with that check to ensure the child understands what's happening.
Makes sense. And what about the duration for non-molestation orders? How long do they last?
A non-molestation order can be made for a specified period, or it can be made until further order.
Until further order. That sounds potentially long-term.
It can be. It differs from occupation orders, which, as we saw, generally have maximum initial durations, especially for cohabitants. An order made until further order essentially lasts indefinitely until the court decides to vary or discharge it.
Okay. So we've covered the two main protective orders under the FLA 1996. Occupation orders, regulating the home, complex rules based on status property, and non-molestation orders, preventing personal harassment, need to be associated. What happens if someone doesn't fit into those associated person categories for a non-molestation order? Or if the behavior isn't strictly molestation as interpreted by the courts? Or maybe it's something like persistent stalking outside a relationship context. Is there legal protection then?
Yes, absolutely. This is where remedies beyond the FLA 1996 come into play, particularly the Protection from Harassment Act 1997, often called the PHA 1997.
PHA 1997.
The sources explicitly state this act provides alternative remedies and is particularly useful in cases of post-separation harassment, maybe when the parties are no longer legally associated under the FLA definition, or for behavior that falls short of molestation but is still clearly harmful harassment. It's also relevant if the perpetrator isn't an associated person at all, maybe a stranger or a neighbor.
The sources ask, why might you use the PHA 1997 instead of the FLA 1996? So the answer is basically if the FLA doesn't fit the relationship or the behavior.
Exactly. if the perpetrator isn't an associated person for an FLA non-molestation order, or the situation isn't about regulating occupation of the home for an FLA occupation order, or if the behavior is more akin to persistent stalking or general harassment that might not quite fit the evolving but still somewhat constrained definition of molestation, thinking back to RETI and CVC, then the PHA 1997 offers another route for protection. It fills those potential gaps.
What's the core of the PHA in 1997 then? What does it actually do?
The PHA 1997 is powerful because it creates both a civil tort of harassment and also makes harassment and stalking criminal offenses.
Okay, let's take the civil tort first. What's needed to prove that?
For the civil tort under Section 1, which allows victims to sue for damages and, importantly, seek injunctions to stop the behavior, three elements typically need to be proven. 1. The defendant must have harassed the victim. The act doesn't strictly define harassment itself, but it implies causing alarm or distress. 2. Crucially, the harassment requires a course of conduct. This is a key statutory requirement under Section 7.3 of the PHA 1997. It means the conduct must have occurred on at least 2 occasions. It's generally not for a single isolated incident. 3. It must be shown that the defendant ought to have known their conduct constituted harassment. This is an objective test. Would a reasonable person, knowing what the defendant knew, have realized their conduct amounted to harassment?
Okay, so a pattern of behavior, at least 2 occasions, causing alarm or distress, and something a reasonable person would see as harassment. And there are defenses available too.
Yes. Section 1.3 provides defenses, such as the conduct being pursued to prevent or detect crime, or under a legal requirement, or if the conduct was reasonable in the particular circumstances.
What about the criminal side of the PHA 1997? What offenses does it create?
The Act creates several criminal offenses targeting different levels of harassment and stalking. Pursuing a course of conduct which amounts to harassment, breaching Section 1, this is a basic offense under Section 2, punishable by up to 6 months in prison or fine. Pursuing a course of conduct that puts a person in fear of violence, this is a more serious offense under Section 4, carrying up to 10 years imprisonment. Pursuing a course of conduct that specifically amounts to stalking this is under Section 2A, punishable by up to 6 months initially. And pursuing a course of conduct related to stalking that causes fear of violence or serious alarm or distress, this is under Section 4A, again carrying up to 10 years.
And the Act even gives examples of what kind of behaviors might count as stalking, doesn't it?
Yeah.
To help identify it.
Yes, Section 2A3 of the PHA 1997 provides a non-exhaustive list of examples. It's helpful to run through them. Following a person, contacting or attempting to contact a person by any means, publishing material relating to a person, monitoring their use of electronic communication, like emails or social media, loitering in any place, interfering with property, and watching or spying on a person. Let's repeat that list. Following, contacting, publishing material, monitoring electronic communication, loitering, interfering with property, watching, or spying. It captures many forms of persistent, unwanted intrusion or monitoring that define stalking.
That list certainly covers a lot of behaviors that can make a victim's life utterly miserable. And the sources mention a restraining order can be issued against an accused under this act, even if they're acquitted sometimes.
Yes, that's right. A restraining order can be made by a criminal court against a defendant, either upon conviction for a harassment or stalking offense, or, importantly in certain circumstances, even upon acquittal. This allows protective measures to be put in place for the victim even if a criminal conviction isn't secured, which can be very valuable.
Building specifically on stalking, the sources also mention the Stalking Protection Act 2019. What did that add?
Right. The Stalking Protection Act 2019 introduced a specific civil order called a Stalking Protection Order, or SPO. These are obtainable in the magistrate's court on the civil standard of proof the balance of probabilities, which is lower than the criminal standard.
And who are they for?
They are specifically designed to cover stalking situations that happen outside a domestic abuse context or where the perpetrator is a stranger to the applicant. So if the FLA doesn't apply because they aren't associated and maybe the PHA civil route isn't quite right, SPOs provide another avenue for protection via the civil courts, specifically targeting stalking behavior. They can impose prohibitions like no contact and also positive requirements like attending a perpetrator program.
Okay, so we have occupation orders and non-molestation orders under the FLA 1996, civil and criminal remedies under the PHA 1997, and stalking protection orders under the 2019 Act. That's quite a toolkit.
Yeah.
How are these orders actually enforced if they're breached? And what about undertakings? You mentioned them earlier. What role do they play?
Let's talk about undertakings first. That's under Section 46 of the FLA 1996. where a court could make an occupation or non-molestation order under Part 4. It has the power to accept an undertaking, which is basically a solemn promise to the court from any party instead of making the formal court order.
Why would they do that?
It's often used where the respondent agrees to abide by terms similar to an order, without the need for a full contested hearing. It can be quicker and less confrontational.
Yeah.
However, there's a crucial limitation.
Which is?
The court shall not accept an undertaking from a party where, if it had made the order instead, it would have been required to attach a power of arrest to it.
So if the situation is serious enough that a power of arrest would normally be mandatory, an undertaking isn't an option.
Exactly. This limitation particularly applies to occupation orders, where violence is proven or threatened, as we'll see regarding enforcement. But if an undertaking is accepted by the court, it's enforceable just as if it were a court order. Breach can lead to contempt of court proceedings.
Okay, so an undertaking is a formal, enforceable promise, but can't substitute for an order where a power of arrest is needed. How are the actual orders enforced then, particularly the FLA orders, occupation orders first?
For occupation orders, the primary enforcement tool, especially where violence is involved, is the power of arrest. This is under Section 47 of the FLA 1996. A power of arrest must be attached to an occupation order if it appears to the court that the respondent has used or threatened violence against the applicant or a relevant child, meaning a child living with or likely to live with either party.
Must be attached.
Yes, unless the court is satisfied that the applicant or child will be adequately protected without such a power. So there's a slight discretion to not attach it, but the default where violence is present is that it must be attached.
So, for occupation orders involving violence, a power of arrest is usually mandatory. It empowers the police to arrest the respondent immediately if they breach the order, unless the court is convinced other protections are enough.
Exactly. And the sources note that if an occupation order is made without notice to the respondent, which can happen in urgent cases under S.45 FLA 1996, the court may attach a power of arrest if it appears the respondent has used or threatened violence, or there's a significant risk of harm to the applicant or child attributable to the respondent. If a power of arrest is attached to any occupation order, a copy must be lodged at the police station for the area so they know about it and can act if called.
Okay, that's occupation orders. What about enforcing non-molestation orders? Did they used to have powers of arrest attached, or is it different now? I think you mentioned a change.
It is different now, and it's a really significant change that strengthened enforcement considerably. Originally, yes, non-molestation orders could have a power of arrest attached by the court on a discretionary basis. However, the law was amended. Breach of a non-molestation order without reasonable excuse is now a criminal offense in its own right. This is under Section 42A of the FLA 1996.
A criminal offense, just for breaching the order.
Yes, and it's potentially serious punishable by up to 5 years imprisonment. Furthermore, it's designated as an automatically arrestable offense under Section 24(1) of the Police and Criminal Evidence Act, 1984.
That sounds like a major shift. So, breaching a non-molestation order is a crime, and the police have an automatic power and maybe even a duty to arrest if notified of a breach.
Yes, precisely. This criminalization provides a much stronger and more automatic enforcement mechanism. The police response upon notification of a breach isn't dependent on whether the judge happened to attach a discretionary power of arrest to that specific order. Breach is the offense, and arrest follows. This is a key way the enforcement of non-molestation orders has been significantly bolstered.
That seems like a really important strengthening of protection. Are there other forms of relief or support mentioned in the sources for victims, perhaps financial or related to housing? Housing seems like a huge issue.
Yes, the sources mention compensation. Victims may be able to seek financial compensation for injuries suffered from the Criminal Injuries Compensation Authority, CICA. Historically, family cases were excluded, but that bar was removed way back in 1979.
But are there still issues?
The sources note that informal rules operated by the board can still limit successful claims in domestic cases. For example, a rule often applied stated the victim and offender must no longer be living together at the time of the claim. This was intended to prevent collusion, but of course it could disadvantage victims who hadn't yet been able to secure alternative housing.
Right. And what about rehousing? You said it's critical.
Absolutely critical. Many victims need to leave their home permanently for safety and rely on public sector rehousing from local authorities or housing associations. The sources outline the process under the Housing Act 1996, and it involves several stages and specific legal criteria that victims need to navigate.
Can you walk us through that process? What does someone need to show?
Okay, typically. 1. The applicant must be homeless or threatened with homelessness, likely to become homeless within 28 days. Crucially, the local authority must consider whether it would be reasonable for them to continue to occupy their home, taking into account the risk of violence or abuse if they return. That requirement comes from the case RV Broxbourne BC XP Wilmoth, VP case name, RV Broxbourne BC XP Wilmoth.
And what if they're in a refuge? Are they homeless then?
Yes. The sources clarify that a person staying at a refuge or other temporary accommodation specifically because of domestic abuse is considered homeless for the purposes of the Act. That was confirmed in RV Ealing LBC XP Sidhu. Repeat case name. RV Ealing LBC XP Sidhu.
Okay, so first hurdle, homeless or threatened with it. What's next?
2. If homeless, the applicant must have a priority need under Section 189 of the Housing Act 1996. Certain categories automatically have priority need. Relevant ones for victims of domestic abuse include a pregnant woman, a person with dependent children, and that CDU case, again, RV Ealing LBC XP CDU, disapproved of authorities requiring formal custody orders, focusing instead on practical dependency, or a person who is vulnerable.
Vulnerable, how is that defined?
Vulnerability can be due to reasons like old age, mental illness or handicap, physical disability, or other special reason. And importantly, the government's Code of Guidance strongly recommends that local authorities treat domestic abuse victims, even without children or pregnancy, as vulnerable under that other special reason category.
So being a victim of domestic abuse should in itself potentially make you vulnerable and thus in priority need. What else?
3. The applicant must not be deemed intentionally homeless under Section 191 of the Housing Act 1996. This means they didn't deliberately do something or fail to do something that caused them to lose accommodation, which was reasonable for them to continue to occupy.
How might that apply in domestic abuse cases?
Well, the sources mention the criticized historical practice of some local authorities classifying victims who didn't apply for exclusion orders, like FLA occupation orders, against their abuser as intentionally homeless, essentially blaming the victim for not legally securing the home, which is now widely seen as unreasonable given the complexities and dangers involved.
That sounds incredibly unfair. Okay, so homeless, priority need, not intentionally homeless. Anything else?
Therefore, finally, if the local authority accepts a duty to rehouse, the accommodation they offer must be suitable and, importantly, permanent or settled to properly discharge that duty and avoid the person still being considered homeless. That point comes from R.V. Brent XP AWO. Repeat case name. R.V. Brent XP AWO.
That rehousing process sounds quite complex, with multiple legal hurdles for victims who are already likely in a crisis situation. The sources mention a Supreme Court case that significantly broadened the definition of domestic violence in this housing context. That sounds important.
Yes, hugely important. Yemshaw v. Hounslow, LBC, from 2011. Repeat case name. Yemshaw v. Hounslow, LBC. This was a landmark case where the Supreme Court considered the meaning of domestic violence, specifically as it applied in the Housing Act 1996. They interpreted the term broadly.
How broadly?
To include not just physical violence, but also threatening or intimidating behavior and any other form of abuse which, directly or indirectly, may give rise to the risk of violence.
So covering psychological, emotional, controlling abuse, too.
Exactly, if it creates a risk of violence. This was a crucial decision because it ensured that the definition for rehousing purposes is wide enough to encompass the full spectrum of abuse recognized in the cross-government definition we started with. It meant a much wider range of victims could potentially be considered homeless with a priority need, moving the focus beyond just physical harm.
That's a really crucial development for victims seeking safe housing, expanding who is recognized as needing that priority help. What about more recent developments in extending protection, things beyond the core FLA and PHA remedies?
The sources discuss several important ones. Building on police powers, the Crime and Security Act 2010, sections 2433. And further strengthened by the Domestic Abuse Act 2021, introduced Domestic Violence Protection Notices, DVPNs, and Domestic Violence Protection Orders, DVPOs.
DVPNs and DVPOs, what do they do?
The sources explain these empower the police, often senior officers, to issue a DVPN right at the scene of a domestic incident. This notice can require an alleged perpetrator to leave the victim's premises and prohibit them from having contact or returning for a short period, usually up to 48 hours.
So immediate police action to remove the perpetrator.
Yes, and that notice must then be reviewed by a magistrate's court, usually within those 48 hours. The court can then issue a DVPO, which can last for between 14 and 28 days, continuing those prohibitions.
So DVPNs and DVPOs provide immediate short-term protection initiated by police, reviewed quickly by the court. Why are these needed?
The sources highlight that they fill a crucial gap. They provide immediate protection right after an incident, when perhaps an arrest isn't appropriate or possible, Or maybe the victim isn't ready or able yet to apply for a longer-term civil injunction like an occupation order, which takes more time. They give the victim vital breathing space and immediate safety in a crisis. The Domestic Abuse Act 2021 broadened the scope and operation of this DVP and DVPO regime further, showing how important it's considered.
That sounds like a very practical tool for immediate safety. What else is mentioned? Forced marriage.
Yes, the sources also discuss protection against forced marriage. The FLA 1996 itself, through an amendment adding Section 63A, introduced forced marriage protection orders, FMPOs.
FMPOs. What are they designed to do?
They're designed to prevent a person from being forced into a marriage against their will, or to protect someone who has already been forced into one. They can impose prohibitions on specific individuals, maybe family members, preventing them from, say, taking the person abroad for a forced marriage, or using threats or violence, or taking other steps towards forcing the marriage.
And there are specific cases cited that show these FMPOs in action.
Yes, the sources give examples like Chief Constable VYK 2010, Chief Constable VA 2010, and RBV FB&MA 2008. These demonstrate the courts using FMPOs effectively to protect individuals. Repeat case names: Chief Constable VYK, Chief Constable VA, RBV FB&MA.
The sources also note that forcing marriage actually became a criminal offense itself, didn't it? Which sounds like a major step.
Yes, absolutely. Alongside the civil FMPOs used for prevention and protection, the Antisocial Behavior Crime and Policing Act 2014 created two new criminal offenses. One of breaching an FMPO and another standalone criminal offense of forcing or coercing someone into marriage using violence, threats, or deception. The sources note the first conviction for this criminal offense occurred in June 2015. This dual-approach civil prevention orders and criminal sanctions provides a much more robust response to forced marriage.
And there are even more recent FMPO cases mentioned that explore some of the nuances.
Indeed. RE-K, forced marriage, passport order from 2020, repeat case name. RE-K dealt with granting FMPOs against someone who actually had capacity to make their own decisions but was still being coerced, and also the power to make an indefinite passport order alongside an FMPO, requiring them to surrender their passport to prevent travel abroad.
And the other one.
Sheffield City Council v. Ors from 2022. Repeat case name. Sheffield City Council v. Ors. This involved a local authority seeking FMPOs for children and raised interesting human rights questions under Article 6 ECHR, right of fair trial, about how to handle sensitive evidence when the application was made without notice to the father, including the potential need to appoint a special advocate to represent his interests regarding the secret evidence. These recent cases show the ongoing development and application of FMPOs in complex, real-world situations.
We've covered so much legal ground: civil orders under FLA, the PHA, criminal law, police powers like DVPNS, DVPOs, housing law, forced marriage protection. How does the Human Rights Act 1998 fit into all of this? Does it impact how courts apply these laws or impose obligations on the state?
That's a really important question. And the sources outline 5 potential connections or implications under the Human Rights Act 1998, referencing analysis by the legal scholar Herring.
Okay, what are they?
1. Article 8. Right to respect for private and family life, home. An occupation order requiring someone to leave their home could potentially interfere with their Article 8 rights. However, the sources note that Article 8.2 allows interference if it's necessary and proportionate for legitimate aims like public safety, protecting health or morals, or protecting the rights and freedoms of others. An occupation order granted to protect a victim from violence would likely be seen as justified under these grounds.
Okay, so Article 8 is relevant, but interference can be justified. What's next?
2. Article 6. Right to a fair trial. Granting ex parte without notice occupation orders where the respondent isn't present in court for the initial order could arguably raise issues under Article 6, which guarantees the right to a fair and public hearing. The sources acknowledge this potential conflict, but note that these orders are usually temporary and subject to review at a full hearing where the respondent is present, which acts as a safeguard.
Right, the without notice aspect is tricky but time-limited. Number 3.
3. Article 1, Protocol 1. Protection of property, peaceful enjoyment of possessions. Occupation orders, especially those requiring an owner or tenant to leave, clearly interfere with this right. But again, like Article 8, this right isn't absolute. Interference can be justified if it's in the public interest, for instance, to protect someone from serious harm, which would likely be seen as a legitimate aim outweighing the property right in that context.
Makes sense. Number 4. Discrimination.
4. Article 14. Prohibition of discrimination. It could be argued, as we discussed earlier, that the differences in how occupation orders are treated based on marital status, especially sections 36 and 38 for cohabitants, compared to 33, 35, 37 for spouses, discriminate against unmarried couples. This potential discrimination could breach Article 14 when read together with other convention rights like Article 8, Family Life Home, or Article 1, Protocol 1, Property.
Has the European Court ruled on marital status discrimination?
The sources note the European Court of Human Rights, ECTHR, hasn't ruled that discrimination purely on grounds of marital status is per se unlawful in all contexts. Cases like Lindsay v. UK and Sahin v. Germany show different outcomes depending on the specific facts and justification offered by the state. So it's a potential argument, but not automatically successful.
Okay, and the final point, Article 3.
5. Article 3. Prohibition of torture, inhumane, or degrading treatment. This is a fundamental, non-derogable right. It can never be suspended or justified. Crucially, the state has a positive duty under Article 3 to protect citizens from such treatment, even if it's inflicted by private individuals, like an abusive partner.
A positive duty to protect.
Yes. The sources argue that in cases of severe domestic abuse that reaches the high threshold of Article 3 treatment, an occupation order might be the only practical way for the state to provide the victim with the necessary protection it's obliged to give under Article 3. Therefore, if a court, faced with clear evidence meeting that high Article 3 threshold, failed to grant an order, that failure could potentially be seen as the state breaching its positive obligations under Article 3.
That point about Article 3 and the state's positive duty is really powerful. It frames the law not just as rules, but as a mechanism for fulfilling fundamental human rights obligations to protect people from serious harm. The sources mention a landmark case from the ECTHR that really hammered this home regarding domestic abuse.
Yes. The highly significant case of Opuz v. Turkey from 2010. Repeat case name, Opuz v. Turkey. In this case, the European Court found Turkey had violated its obligations under not only Article 3, due to failure to protect from severe violence, but also Article 2, the right to life, as the victim's mother was killed, Article 6, fair trial, due to ineffective investigation prosecution, and Article 8, private life, because of the state's systemic failure to protect the applicant and her mother from years of documented, escalating domestic abuse by her husband and its failure to adequately prosecute him.
Wow. So the state was held responsible for its failure to act effectively.
Absolutely. Opuz v. Turkey is critical, internationally and domestically, because it unequivocally underscores the state's responsibility under the Human Rights Convention to take positive, effective steps through its laws, its policing, its judicial system to protect individuals, particularly women, from domestic violence and ensure their safety. It makes clear that just having laws on the books isn't enough. They must be applied effectively to prevent human rights violations.
That case provides a really strong human rights backdrop to the state's duty to provide effective legal protection, reinforcing the importance of the tools we've been discussing all this time.
Absolutely. It frames the importance of having and, crucially, effectively using legal tools like occupation orders, non-molestation orders, and a responsive criminal justice system within the broader context of upholding fundamental human rights.
We have covered an enormous amount of ground today. We've looked at criminal law remedies, assault, rape, coercive control, judicial separation, the incredibly detailed and complex world of occupation orders under the FLA 1996, with all their nuances based on status and property rights, sections 33, 35, 36, 37, 38, and that crucial balance of harm test. We looked at non-molestation orders, the definition of associated persons, and molestation. We covered the PHA in 1997 for wider harassment and stalking, the Stalking Protection Act 2019. We've discussed the various enforcement mechanisms, power of arrest, criminalization of breach, compensation, access to rehousing, and the vital Yemsha case. We touched on newer protections like DVPNS, DVPOs, and FMPOs, and finally the significant dimension added by the Human Rights Act, especially Article 3 and Opuz v. Turkey. How can someone listening pull all of this together, especially if they're trying to understand it thoroughly, maybe for an exam, or just to be really well informed on this critical area? It's a lot to take in.
It is a lot, and connecting the dots is absolutely key, just as the source materials imply by including self-assessment and problem questions. Applying these concepts effectively isn't about rote memorization of every single case fact, although knowing key cases is important. It's more about understanding the overall framework and knowing which legal tool or which specific section fits which type of situation.
So what are the absolute core distinctions people need to keep clear in their minds?
Okay, let's recap the main ones. First, the fundamental difference between criminal remedies, prosecution for specific offenses like assault, rape, stalking, coercive control, and civil remedies like orders under the FLA 1996 and the PHA 1997.
Mm.
Repeat terms, criminal remedies, civil remedies, two different routes. Then, within the civil remedies, focus on the two main types of FLA orders: occupation orders, about the home, and non-molestation orders, about personal protection. Repeat terms, occupation orders, non-molestation orders. For non-molestation orders, the absolutely crucial gateway concept is who qualifies as an associated person under Section 62 to 336. Repeat term, associated persons. Remember that list is broad: spouses, cohabitants, relatives, intimate partners, etc., but it is a defined list, as MVD showed.
And molestation itself.
For molestation, remember it's undefined in the statute. The key takeaway from the case law, CVC 1998, Re-T, is that courts interpret it as conduct, causing significant harassment, alarm, or distress, requiring good sense and judgment, focusing on the effect on the victim. Repeat cases and concept. CVC, Re-T, definition of molestation. Now, for occupation orders, this is where the real complexity lies. You absolutely must understand the different categories of applicants and the specific sections that apply based on property rights and relationship status. Section 33, entitled Home Rights, Spouse CP. Section 35, disentitled Former Spouse CP. Section 36, disentitled former cohabitant. Section 37, neither spouse CP, entitled. And Section 38, neither former cohabitant, entitled. Repeat section numbers and distinctions. Section 33, Section 35, Section 36, Section 37, Section 38, entitled versus disentitled, spouse CP versus cohabitant.
And the different tests applied under those sections.
Critically, remember the mandatory balance of harm test under Section 33.7. Understand that this powerful test applies to applicants under Section 33 and Section 37. Spouse CPs. If the applicant child's likely significant attributable harm, if no order is made, is not outweighed, the court must make an order. Contrast this sharply with applicants under Section 36 and Section 38 cohabitants, where the harm factors are considered, but the court always retains discretion. Repeat balance of harm test and the crucial difference in application based on status, plus the limited duration for cohabitants.
And the case law helps illustrate this.
Yes. Remember how the case law illustrates these principles? The draconian nature of ouster orders and the tension with property rights, Chalmers v. Johns, Re Y. But how courts can balance these, especially if alternative accommodation exists, Grubb v. Grubb, and how courts might be exercising discretion even without physical violence under S.336, Dolan v. Corby, Re L. Repeat key cases and concepts, Chalmers v. Johns, Re Y, Grubb v. Grubb, Dolan v. Corby, Re L, draconian orders. Then understand when the PHA 1997 is the relevant act. Repeat act name, PHA 1997. Typically, when the FLA in 1996 doesn't apply because the parties aren't associated or the behavior is more general harassment or stalking outside the molestation definition, remember the key elements for the civil tort, course of conduct ought to have known, and the different criminal offenses, including stalking. And recall the list of stalking behaviors from the act. Repeat list. Following, contacting, publishing material, monitoring electronic communication, loitering, interfering with property, watching, spying.
And finally, enforcement and other protections.
Know the key enforcement mechanisms. The power of arrest, mainly for occupation orders involving violence, the criminalization of breaching a non-molestation order leading to automatic arrest, the possibility of compensation, CICA, and importantly, the complex process for rehousing, homelessness, priority need, vulnerability, intentional homelessness, remembering the crucial impact of the Yemshaw case, widening the definition of domestic violence for housing. Repeat methods and key case, power of arrest, criminalization of breach, rehousing Yemshaw. Also be aware of the newer protections, police-led DVP and SDVPOs, and specific forced marriage protection orders, FMPOs, and the criminal offense. Repeat key acronyms terms, DVP and DVPO, FMPO, and always consider the relevance of the Human Rights Act, particularly the state's positive duty under Article 3 to protect individuals from inhumane treatment, powerfully highlighted by the European Court in Opus v. Turkey. Repeat articles in case. Article 3, Opus v. Turkey.
That is a fantastic summary for pulling all those threads together and seeing how they interconnect. The sources suggest that when faced with a scenario, like in an exam problem question, the process is really about systematically working through these points. Identify who are the parties, what's their relationship status, spouse, cohabitant, former, relative, etc. Are they associated? What are their property rights? Owner, tenant, no right, which FLA section applies for occupation. What's the problematic behavior? Violence, threats, control, harassment, stalking, forced marriage. What remedy is needed? Protection from contact, right to occupy the home.
Exactly. Then you work through the relevant sections, FLA 1996, which specific section, PHA 1997, FMPOs. You apply the correct tests, the mandatory or discretionary harm test for occupation orders, the associated person and molestation criteria for non-molestation. You consider the specific factors the court must look at for that section. And you use the key case law we've discussed to support how the court is likely to interpret those tests and factors in this specific scenario.
Like in the Tom, Rose, Sarah scenario mentioned in the source. You'd check if Rose is associated with Tom and Sarah for a non-molestation order, and if their behavior is molestation using CVC and RETI. For occupation, you'd determine Rose's status, likely disentitled cohabitant under S.36 if Tom owns Trent's, and Sarah's, maybe entitled co-owner under S.33 if she ends with Tom. Then apply the right section of S.36 for Rose, discretionary harm test, limited duration, maybe S.43 for Sarah against Tom, mandatory harm test applies. You consider all of factors, housing needs, conduct, and especially the needs of their child, Dawn, and her autism, mentioned in the source when deciding if an order is likely.
Precisely. It's about methodically weaving together the specific statutory provisions, the definitions within the acts, and the interpretation given by the courts through that key case law. Understanding why the law makes certain distinctions, like spouse versus cohabitant, and how judges actually apply the tests in practice is crucial to applying the law correctly to any given set of facts.
The sources also hint that maybe Part 4 of the FLA 1996 on its own isn't seen as fully adequate anymore, that recent reforms like DVP and SDVPOs suggest a recognition that a multifaceted approach is needed.
Yes, that seems a fair assessment. The very introduction of these newer police-led powers, the standalone coercive control offense, the specific stalking protection orders, and the ongoing strengthening under the Domestic Abuse Act 2021 all suggest that while the FLA 1996 was a huge and vital step forward, domestic abuse is such a pervasive and complex problem that effective protection really requires a combination of tools: immediate police powers, robust civil remedies, effective criminal law enforcement, and broader support like accessible rehousing and specialist victim services. The law provides crucial tools, but it's definitely part of a much larger picture needed to tackle the issue.
That brings us towards the end of this deep dive. It's incredibly clear that the legal framework designed to offer protection against domestic abuse in England and Wales is both extensive and, well, pretty complex. It provides crucial civil tools like occupation orders and non-molestation orders, alongside criminal law, PHA remedies, DVP&S DVPOs, and FMPOs.
Indeed. But as we've explored in detail today, navigating this framework effectively requires a really precise understanding. You need to know the specific criteria, the statutory definitions, those distinct categories of applicants based on relationship status and property rights, and crucially, how the courts have interpreted and applied these laws through key case law.
And as we've definitely seen, achieving protection isn't always straightforward, is it? It involves difficult considerations of balancing competing rights, proving harm according to sometimes complex statutory tests, and overcoming very real challenges in enforcement and access to vital support like safe rehousing.
Which leads us to a final thought. Despite the numerous legal tools available and the ongoing reforms aimed at strengthening protection, the tragic prevalence of domestic abuse suggests the legal system alone cannot solve this profound societal problem.
So this leaves us with a significant question for you, our listener, to consider as you reflect on all this material. What wider societal changes, what different support structures, or what preventative measures are needed alongside the legal framework we've discussed today to truly reduce domestic abuse and protect individuals from harm in their own homes and relationships?
A really important question to ponder.
A powerful thought to leave you with. A huge thank you once again to the University of London for making these valuable educational materials available for us to explore today. It's been incredibly insightful digging into them.
Absolutely. And just a reminder, this deep dive was brought to you by Sinorbit Academy, Sri Lanka, purely for educational purposes.
And finally, to anyone listening who is preparing for exams, perhaps using this material, we sincerely wish you the very best of luck. You've clearly put in the work to understand this complex and vital area of law, and you can do this.
Good luck. We hope this helped.
And that's our deep dive for today. We hope you found it insightful and helpful.